I think we all know that's false. Sexual harassment can manifest itself in a lot of different ways. It can be inappropriate language, images, and the like. So physical contact, not a requirement. Second, to qualify as sexual harassment, the parties have to be of the opposite sex. Again, false. I think we all know there can be same as well as opposite sex sexual harassment. And again, as is entered into the consciousness and the language, we have issues with gender fluidity, transgender, all of these sorts of things. All of it falls within the realm or the arena of sexual harassment. 3, if an employee submits to a request for sexual favors, they nullify their right to file a sexual harassment complaint. Again, this is false. And the reason that it's false is the word submits, because submission does not necessarily mean consent or agreement. And the classic example, as we'll learn, is a situation where you may have someone in a supervisory role who is pressuring someone to go out with them and threatening their job or promotion or something like that. 4, gossip about a manager-employee affair is not enough to support a sexual harassment claim by another employee. This is false. Sometimes people get hung up on this, but think about this very simple example. Let's say you have 2 people who are gossiping about this alleged affair that's going on, and perhaps they're going into very graphic detail, and a third person walks by and overhears this. Might they be offended? Might this constitute sexual harassment? Yes, yes, clearly it does. And, you know, I wish I had a magic cure for gossip in the workplace, but I don't. But nevertheless, it doesn't mean that it's going to absolve people of potential claim for sexual harassment. 5, claims as to the intent of the alleged harasser, for example, he didn't mean anything by that, or he hugs all the women, are considered when determining whether or not sexual harassment has occurred. That answer is, again, false. What we'll learn is that what we consider is not the intent of the harasser, but rather the subjective feelings or perception of the person who is the recipient or the victim of sexual harassment. 6, organizations are responsible for the actions of employees, but not for the conduct of non-employees, such as those who are vendors or contractors for the county. Again, this is false. This is written into our policy. No, we are responsible for the conduct of our vendors, contractors, and employees should not have to tolerate sexual harassment, harassing, discriminatory, violent comments, as we'll learn in the second segment. Pinup calendars, such as Sports Illustrated swimsuit calendar, are considered personal items and therefore not classified as sexual harassment. Therefore, and we could add in the workplace. Again, this is false. These are inappropriate images. And in the modern era, I think that we would say things like screen savers, images on cell phones, all of these things can be avenues or delivery mechanisms for inappropriate content. Now, just as a matter of almost social trivia, if you will, based on my personal observations, one of the very few workplaces where you still see these types of calendars prominently displayed, think in your minds, auto mechanic shops. Auto mechanic shops. And I don't know why that is, because clearly there are, male and female mechanics, male and female customers. I don't know why these things have not been sued out of existence at auto mechanic shops, but there they are. So, who knows? Maybe when I retire, I'll open up a cottage practice and go around the country suing auto mechanic shops on sexual harassment complaints. 8, a supervisor can claim sexual harassment against an employee even if he or she is in a position to fire that employee. This is true. It is true. It doesn't matter your position. Sexual harassment can happen both from a supervisor, directed towards a supervisor. In fact, a few years ago, I was looking at some Department of Labor statistics, and in that particular year that I was looking at, they indicated that up 64% of all the sexual harassment claims that were filed by supervisors against an employee who reported to them. Kind of interesting, I find, over 50% in that year. 9, there are certain circumstances, for example, hearsay, denial by a rumored victim, where a supervisor is not required to investigate. Again, this is false. We investigate all claims that come in. That is the duty and responsibility of the county. HR conducts many, if not all of those. So no, we do investigate everything. And just real quickly, John, I see you came on the line. Could you mute your microphone? I'm getting some noise coming in through your line, I think. 10, a company can create thank you. A company can create standards and policies that are more stringent than the established laws against sexual harassment. This is true. And in fact, if you can recall, go back a little more than a year ago, before the pandemic and all of that, one of the biggest stories in the news dealt with this increased awareness of sexual harassment in the workplace, the Me Too movement, and so forth. And lots of companies, the county included, started evaluating their policies to see, first of all, if they were in line with law, and second, if they needed to go beyond that. And to some degree, the county's policies do exceed what is required under state and federal law. 11, and I want you to think about this one, because this is a question that often gets many people hung up. It takes several incidents over a period of time to fully establish a hostile office environment. Think about that. A lot of people want to immediately think that is false, and I have to talk like a lawyer here. Generally, the answer is true. And think about the word. We're talking environment. So one way of putting it is a single drop of rain does not mean it's raining. Or the example they kind of classically use is, let's say we have a 30-year employee. And over a 30-year period of time, they experienced 3 isolated incidents of sexual harassment. Is that going to be considered a hostile environment? Probably not. There's just not what they call pervasiveness of the behavior. On the other hand, let's say we have a new employee, and on their first day, they experienced 3 incidents of sexual harassing behavior. Might that be considered a hostile off environment? Quite possibly, yes. But, and again, my apologies, I have to talk like a lawyer here, but I want to give you a complete answer. There are cases where it's been successful claims for what they call single incident hostile office environment. These types of cases tend to be on the more extreme level, if you will. They almost always involve physical contact and may even constitute criminal behavior. So again, the answer is generally it's true. What the courts will look to is there this, what they call severe and pervasive environment behavior that is impacting a person's ability to do their job. And if you think about it, even just sort of for a moment, you think, well, let's say we've got this single incident of sexual harassment. The company investigates, they take corrective action if it's determined to be founded. Most courts are not going to hold a company liable if they acted quickly and expediently with regards to the incident. 12, if an incident of sexual harassment occurs at an official company function, the employer is liable even if the event is held after hours or off company property. True, this is true. And what is our classic example? The office party, right? Yes, Raina got it. And I will tell you, office parties are the bane of existence for human resources professionals, employment lawyers. And if you add alcohol to the mix, you can add a couple of zeros to the amount of money you're probably going to have to pay out in a potential sexual harassment claim. But any sort of official company event, anything that has the imprint or the endorsement or the sponsorship of the company or the county, the company is going to be potentially liable. And I can tell you that there have even been some cases. Now, what do we all do? We go to the office party, and then what do a few people do after the office party? We go to the after party, right? questions have been raised as to whether or not the after party is, if that's where the sexual harassing conduct occurs, if the company is liable. And there have been some successful claims about that. In fact, there is one very well-known case involving a very big, well-known company in New Mexico where someone was successful in bringing that type of claim. So we have to be cautious. 13, sexual harassment tends to be power-driven rather than sexually driven. This is true. I think all of the good data supports that the motivation for this type of behavior tends not to be driven by desire or even procreation, but rather by exerting power over another individual. 14, an employee wishing to report an incident of sexual harassment should always follow the established chain of command when reporting their claim. This is false. And the reason it's false is the use of the word always. Because if the sexually harassing behavior is coming from someone within the immediate chain of command, that may mean a person may have to jump hierarchy, go straight to HR, but they have to, obviously pursue the avenue that isn't directly at the source of the sexually harassing behavior. 15, situations involving sexual harassment are usually self-contained, causing little or no effect on the rest of the organization as a whole. Again, this is false. I think we've all worked in other places, perhaps, and we've known about things that have gone wrong, even if we haven't been involved or been witnesses. And we know that because, like we said before, people talk. People like to tell stories. And that is just a truth in the workplace. So that's the quiz. Congratulations. You all got 100, right? And so anyway, this is just a way of getting you thinking about these materials. So with that, what I'm going to do is I'm going to share my screen and I'm going to bring up the slides for the rest of this portion of the presentation. So hopefully you will be able to see that. And let me put us on full screen. So can you all see the slides now? Okay, thanks. So in the handbook that you should have received in the first portion of NEO, there are a series of what they call worksheet questions, and these slides are intended to address these as a way of orienting you to understanding what the county's policy with regards to sexual harassment is. And by the way, I should mention that when I talk about, even though we're talking about sexual harassment specifically this morning, this applies to other things such as gender discrimination, racial discrimination, and the like. All of these sort of flow out of the federal law known as Title VII of the Federal Civil Rights Act of 1964. It's a law that's over a half century old. It's as old as I am. It's precisely as old as I am. And many times people say, well, since this law's been around for so long, why are there still so many claims? Why is it still so controversial? And we'll see why some of that is as we go along. So just to start out, what is our definition of sexual harassment? Well, generally accepted, and this we'll see in the official EEO definition in a moment, unwelcome sexual advances. Now, key in on that for a moment. It's the unwelcomeness that the person has to prove. And sometimes that can be very difficult about whether or not this was unwelcome behavior. It's requests for sexual favors and anything verbal, physical conduct of a sexual nature that, again, is going to impact a person's ability to perform their job or create that, again, intimidating, hostile, or offensive work environment. And as we learned from the quiz, it can be either same or opposite sex, and it can happen in subtle ways. For example, let's say someone in the office tells a dirty joke. Well, that's a form of sexual harassment. And if it doesn't get called out, then it's going to be assumed not only by that person, but by the people that heard it, that that's going to be acceptable conduct. And many employment lawyers will tell you, if you don't call out the behavior in the first instance and try to correct it, people will graduate, as they say, from kindergarten type sexual harassment to graduate school very, very quickly. So keep that in mind. Two different types of sexual harassment that are recognized under the law. first is quid pro quo, or this for that. This is a situation where we have someone in some sort of position of authority, in other words, the ability to hire, fire, promote, demote, perhaps scheduling, all of those things that impact a person's employment. And they use that authority as a means to induce someone to submit to some sort of sexual activity. In this type of sexual harassment, some sort of economic threat is almost always involved. And it can be implicit or explicit. And it can be subtle things like, well, you could really advance your career here if you would just go out with me. Something, things like that. Now, I will tell you, when these laws were first established about 50 years ago, I think this was probably the predominant form of sexual harassment. And I can even remember, just to show you how old I am, in the 70s, when I would watch my Saturday morning cartoons, they would break in with these PSAs, public service announcements, trying to educate the public about sexual harassment. And usually it was these very sort of stereotypical roles. It was the typical male supervisor, the female support staff person, and the male would go like behind the female's desk, and they would make all of these sort of implicit comments, like I just said. You could really, get ahead of here if you would just learn to use your assets, and things that we know are wrong, and yet so many of these complaints, and this really is what was uncovered, if you will, with regards to the Me Too movement, was how prevalent these types of behaviors are within all sorts of work environments, and how it is one of the most underreported types of violations there is in the workplace. Because, honestly, people may be afraid. They may be afraid to report it. They may be afraid for their careers and so forth. The next type of sexual harassment we've already talked a bit about, hostile work environment. This is where you have a situation where the harasser is creating this, and these are the key words here, severe and pervasive condition that is altering the victim's employment and creates this abusive environment. Distinction here is that economic threats are generally not involved. And this, I would say, is now, in the modern era, the most prevalent type of harassment claims that we see. It's the hostile office environment claim. I think most employers know that quid pro quo is out of bounds. I can't say it's been completely eliminated, but hostile office environment, the most common type of sexual harassment claim that we see. This slide is the official DOJ EEOC definition of sexual harassment. And as we can see, we've already covered most of it, but I do want to make a couple of points here. And one thing, again, speaks to sometimes the difficulty in proving these types of claims, and that's at the bottom here. You have to establish or prove that the conduct has had the purpose and effect of reasonably interfering with an individual's work performance and creating that hostile environment. Now, sometimes people are a little surprised when I tell them that these laws have been around for over 50 years. And they say, well, why? Why is there so much litigation about this still? Well, one thing to keep in mind is that since even though the law was established in 1964, it wasn't until 1986 that the Supreme Court ruled that Title VII does indeed cover sexual harassment. And there is still, to some degree, and this is very recent, like up to last week, breaking news here, there was controversy over whether or not Title VII covered the LGBTQ community. Now, up until, I have to say, last Wednesday, the Department of Justice, under the prior administration, took the position that Title VII did not cover the LGBTQ community. Now, last June, and I have to correct myself because I misspoke last week about this. Last June, the Supreme Court, in a 6-3 decision involving a case in Clayton County, ruled that Title VII does in fact cover LGBTQ community in employment cases. Now, given that decision, the prior administration still argued that, well, that's a narrow ruling. And so it doesn't cover that community for things like housing and so forth. And on Friday, the new administration, the Biden administration, found a memo directing under the prior administration that DOJ to take that position, and they're now pulling that back. And just this morning, I saw that I believe the president is going to sign a new executive order dealing with transgender people in the military. So these things are evolving as we go along. But I don't want you to be too concerned about this in a way, because in addition to Title VII in New Mexico, we have something, a state law known as the New Mexico Human Rights Act. And that clearly covers discrimination against people in the LGBTQ community. So we have to consider both state and federal law. So as we learned from the quiz, you do not have to tolerate sexual harassment from our contractors, our vendors, and the like. This is written into the policy. You can see sort of the elided version of the language there. And again, keep in mind that submission to sexual advances does not nullify an individual's ability to still file a complaint. And again, that would be likely in a more of a quid pro quo situation. So reporting, we have these incidents have to be reported. And if you especially find yourself on the receiving end of inappropriate conduct, language, behavior, first thing I suggest to people is make your disapproval known immediately to the harasser if possible. Why do I say if possible? Well, again, I understand sometimes people can become fearful, especially if the harassing conduct comes from a supervisor or someone in a position of authority over them. But nevertheless, document, document, document. Make a written record, date, time, what happened, who was a witness. This is critical material that HR is going to need in order to be able to conduct a thorough investigation of any claims of sexual harassment. And so the more information we have, the better off we are in terms of being able to thoroughly investigate. And the problem often becomes in, again, proving some of these cases is when we get into the classic, what they call he said, she said situation, where you just have two individuals, one saying this happened, the other one denying it, and no other corroborating evidence one way or the other. Again, in the modern era, I think we have less of these experiences because people tend to, it tends not to be an isolated incident. They tend to use other means like email, text messages, and the like. So we tend to gather the evidence that way. And, you know, currently over the past year, I guess sort of naively thought that, well, we should probably see a decrease in incidents of sexual harassment because more people are working remotely and so forth. No. That has not been the case. In fact, even people, if they're meeting through Teams, Zoom, what have you, have found new and creative ways to violate sexual harassment policy. So we, again, have to watch ourselves. We have to watch our language. We have to watch what we throw up on a screen and so forth. And then finally, just so you know, these incidents have to be reported to HR. So again, they can conduct evaluate or investigations and recommend whatever corrective action may be necessary. So if you are a supervisor, what should you do? Well, first of all, if you are a supervisor and you're made aware of a situation involving sexual harassment, you should deal with it expeditiously and fairly. And by that, I mean you deal with it as quickly as possible, again, using HR as a resource, but also treat everyone the same. It is sometimes a sad commentary when I have to tell managers that when I say treat everyone the same, I mean hold everyone accountable to the same rules. I don't mean let everyone break the same rules. And just a quick example of this, and this is an experience my wife had. My wife's not an attorney. She's a scientist. She has many more degrees than I do. She's far more intelligent than I am. And nevertheless, this is a situation that occurred to her one time. She was in a meeting, big conference room, lots of people there. And at one point in the meeting, she said, "Hey, can we take a quick break? I need to use the restroom." Or as they like to say, "I need a bio break." And a male who was sitting right across from her said, "Here's a cup." Okay. Horribly offensive. Sexually, or at least harassing, probably sexually harassing behavior. And to his credit, my wife's manager, who was sitting next to her at the time, said, "I think that's an EEO violation." Shut him up right then and there. And the interesting side note to that is that person was ultimately fired off of that project. My point in telling you this is, again, when we call out behaviors like this in the first instance, it is more likely to stop it. And you don't have to be a supervisor. If you are a coworker and you see inappropriate language, conduct going on, people are just as willing to take it from a coworker as they are from the supervisor. And at least they are then put on notice, if nothing else. So what about the circumstances where you yourself may have done something or said something that may offend someone? Well, first of all, ask. And if you have, apologize. I mean, I can't tell you the number of times where a circumstance has failed to escalate simply because the person was willing to take responsibility, ownership, and make an apology. And we have to constantly be on guard with regards to our behavior. Over the 50-year history of these laws, have the successful claims for certain behaviors, have they changed? Absolutely. If you look at the cases back from the 70s, horrible conduct that was going on, claims being made, and the cases would be dismissed or fail on summary judgment because judges at the time said, it's fine, deal with it. It's just the way life is. Well, I don't think we're in that's just the way life is stage anymore. I think, again, with the heightened awareness of these types of behaviors, it's just simply not acceptable. And just so you know, the numbers that I've read, and again, keeping in mind that this is one of the most underreported types of behaviors in the workplace, the likelihood of someone encountering sexual harassment during their careers, for women, the numbers are about 1 in 3. 1 in 3. For men, it's about 1 in 6, 1 in 7, somewhere around there. And those, I just have to say, to me, they're somewhat startling, but with regards to this increased awareness through the Weinstein case, Me Too, et cetera, all I can say is it's about time. It's about time that we finally started taking this seriously. What is the standard or the criteria for an environment to be considered hostile? 2 basic requirements under the law. First is it has to be subjectively perceived as being abusive by the person who's affected. And secondly, and again, more difficult to prove, has to be objectively severe and pervasive enough to create a work environment that a reasonable person would find to be hostile or abusive. Now, who's a reasonable person? When I ask most people that question, they tend to think they are. Well, maybe, but really what we're talking about here is some third-party neutral. In other words, judges, juries, arbitrators, hearing officers, someone who doesn't have a stake in the outcome, objectively trying to view the circumstances to see if they would reasonably believe or come to a belief that this type of behavior was sufficiently severe and pervasive to be found to be abusive. Sometimes, again, it can be a very, very high bar for plaintiffs, victims to meet. What should you do if you see it? What's the old saying? See something, say something. Or if you're a supervisor, see something, stop it. Stop it. Because again, every time this type of behavior is not called out, it will be assumed that it is appropriate. And now we have this escalating or spiraling problem. Also, just be aware that when you have these reports, you need to report them to HR so that they can do the investigation. And one final note here, they may have mentioned this in the previous session that you did in NEO, but it is a term and condition of employment with the county that if you are asked to be a witness in an investigation, you are required to cooperate. And this is true even if you may be in a union, there may be different protections there, but you still are required to cooperate. And if you refuse to cooperate, that can become a basis for discipline. And this is a very common requirement. I think just about every employer has this. So we've talked a lot about sort of from the beginning of an incident, reporting and investigation, et cetera. What happens after the investigation is complete? Well, for the majority of our workforce, and these are our rules and regs employees, after HR has completed its investigation, it then goes to a decision-making panel. There are 3 members who sit on the decision-making panel: county manager, human resources director, and then a third designee appointed by the county manager. And so there are 3 actions that they can take once they have received a completed investigation. The first one is if they find that there is enough evidence to support the claim, then they can sustain it. They can obviously order it to stop, impose sanctions, discipline, up to and including termination. You can be terminated for violating the county's sexual harassment policy. Recommend the restoration of any lost benefits. Now, this would be a circumstance where, again, perhaps if someone was fired and they got and they had a good sexual harassment complaint, they would be reinstated. Another circumstance we might contemplate is if they were passed over for promotion or denied the ability to test in for a possible promotion. All of those things could come back to them. Secondly, they can order a further investigation not to exceed 10 business days. So a situation where they may require additional material, some sort of supplementary report. And finally, they can dismiss it if it is found to be without merit. Now, can we imagine a circumstance where someone might file a good faith harassment complaint and it still be found to be without merit? Yes, we can. And let me just give you a quick example from my experience. And this is when I was representing another agency up north. There was a circumstance where the report came in and the person came in and said, every time I pass by Dave's desk, he winks at me. He winks at me. Possible sexual harassment? Yes. Do the investigation. Turns out Dave has a medical condition that causes involuntary eyelid movement. Real condition. He wasn't just winking at this person, he was winking at everybody. So good faith complaint? Yes. Found to have merit? No. And it created a whole other host of issues because even though there was no finding of sexual harassment, we did have to deal with other issues such as ADA accommodations, HIPAA, and the like, things I know you're all familiar with, but these things do happen. So on the other side of it, what about someone who makes a false accusation? Well, false accusations do occur, and when these false, malicious types of complaints are made, then that can subject the person to discipline as well. Now, the most common times where we see this are in this situation, where you have an employee who's being investigated for some other wrongdoing, stealing, time card fraud, what have you. And then they make this complaint, thinking that if they make a complaint, it will stop the other investigation and they'll be protected because if they are disciplined, they can then claim retaliation. Well, that's not how it works. If you make a false complaint, then now you're on the hook for 2 problems. Whatever you were being investigated for in the first instance, and also for filing a false complaint. Sometimes proving the falsity of a complaint can be a challenge, but nevertheless, it's written into the policy that this is a violation. So a question we get sometimes is, what parts of an investigation are confidential? Well, this gets tricky because, as I'm sure you're all aware, the county, as a public agency, we're subject to open records laws. What I can say is we try to keep it as confidential as possible during the course of the investigation. However, and this should make sense to you, the identity of the person who is making the complaint has to be revealed to the person who is accused of committing the harassment and also to any witnesses. And that just makes sense. How else could you respond if you didn't know who was making the accusation? Beyond that, once it's done, we take steps to protect people from retaliation. The report itself, especially if it gets appealed on up to, say, district court or something like that, it's likely going to have to be released to everybody involved. And at that point, it becomes relatively public. But the point is we're subject to these open records laws, but we try to keep the confidentiality of the investigation preserved. Consensual relationships. This is a part of the new county, I say new, it's probably been around a couple of years now, new county's policy. And this is similar to nepotism. It is an attempt to try to address those circumstances where you have two people who are dating, who are in some sort of romantic relationship, to avoid them being in a direct supervisor subordinate type of relationship as well. So, I mean, obviously we cannot legislate or regulate love out of the workplace. It's going to happen. But what we can do is make sure that when people are involved in a relationship, that one isn't supervising the other. So in those circumstances, we just have to we have to change up the chain of command, basically. And we do the same in a situation involving nepotism. The distinction here is nepotism involves either spouses, people who are related by blood or adoption. This type of a situation we're dealing with is, people who I guess we would say are just dating. And they can still be fraught with some legal pitfalls. And in my experience, again, it generally tends to occur with how do I put this delicately? The shorter term relationships, shall we say. But nevertheless, this is an attempt to try to at least make sure that the management chain is appropriate. So that's the end of that part of the presentation. So let me take us off of share screen just for a moment and just ask people if they have questions, comments, anything that you're curious about that I covered that you may want to know more about or wasn't unclear. You all smile and nod your heads, and so there's perfect understanding. Well, let me just address one thing, a question that came up last time I did this training last week. Somebody asked me the question about what is the difference between, say, sexual harassment and discrimination. So let me just sort of make that distinction real quickly. You could have a circumstance, let's say, for example, where you have a female in the workplace who never gets promoted, all the other males in the workplace get promoted, and same experience and so forth. Well, that might be an instance of what we would call gender discrimination, but it might not be a case of sexual harassment, because there's not necessarily a sexual component to it. And that can be true, again, with what we call the protected classes. And the protected classes include race, national origin, religion, religious affiliation, and there are other state and federal laws that protect other categories, such as age, if someone is pregnant. And so just keep in mind that our policy is not actually called a sexual harassment policy, it's called an anti-harassment policy, because it is intended to cover all of these types of circumstances. So just wanted to hopefully make that clear. Anything else? Anybody else? I know you're all nodding and smiling. So, but truly, this is your time if you have questions about this. If not, then I think what I'd like to do is take about, we're about 7:50. I think maybe take about a 5-minute break so that you can get up, refresh your beverage or whatever, and then we'll come back and we'll do the segment on workplace violence. So see you in 5. Okay, it's 7:55. Did people make it back? Okay, two of you. So John and Daniel, just want to make sure you're there still. Okay, Daniel raised his hand. John, you with us? I think he may be. So again, because I want to sort of keep us on time here. Yes, John, I think I see. Ah, very good. Um, so I want to move on into the next segment, which is dealing with the county's workplace violence policy. And again, in the materials you should have in your employee handbook, you have a copy of the policy. And so what I'm going to do is I'm going to go through sort of the basics, some specific questions, and just talk about things in terms of how we try to keep employees within the county safe. So let me bring the slides back up. Again, hopefully you can see those. So, whoops. So in the county policy, it talks about how the county has what they call a zero tolerance policy for workplace violence. And what does that mean? Well, sometimes people will just naturally kind of gravitate to, well, that means you're automatically fired for committing an act of workplace violence. And termination is a possibility, but as we learned with sexual harassment, these things can happen on a sliding scale. So I think the better way of thinking about our zero tolerance policy is to say that any incident of workplace violence is a disciplinable offense. Any incident of workplace violence is a disciplinable offense. Doesn't necessarily mean termination, but it can be. Because again, workplace violence can take several different types of forms. And on this slide here, you can kind of see the different degrees or levels of workplace violence. For example, shaking a fist, throwing things. How many of you have worked with someone who would throw the stapler or throw the mouse? I did a training once for another group, and they came to me and said, well, we have someone who works for us who every time they get angry, they go in their office, they close the door, and they punch the wall. And I said, well, okay, that's still not going to be acceptable behavior for a couple of different reasons. First off, they could be hurting the wall, and that's county property. But second, people are aware of it. And because they're aware of the behavior, that can create that fear and intimidation. And more importantly, perhaps, is the fact is, how do we know that punching the wall today isn't going to lead to punching a person tomorrow? Verbal or written threats. When we do these sessions in person, there's a video we show, and in one point in the video, it's all these various scenarios of examples of workplace violence. In one portion, someone comes up to someone and says, I'm going to put you in a place where you're never going to be able to say anything to anyone ever again. Okay, one of those veiled threats, if you will. And we can wonder, well, where would that place be? Wakanda? I don't know. But the point is that it doesn't have to be so explicit that, and we've dealt with situations like that where someone has said something like, I'm going to get revenge or something like that. Harassing behavior, all of those things that tend to humiliate, embarrass, intimidate people, bullying. You see that word there on the slide, bullying. Where is the area where we tend to associate bullying with more commonly? I think it's probably in the educational realm, right? And, I remember a few years ago going to visit my sister out in Arizona, and she has two kids who are about 10 and 12 at the time. And I asked them, at what point in school did they start talking to them about bullying? And they said they couldn't remember a time when they didn't. And my point is that though bullying is no less of an issue in the workplace, and many times people feel like they've been subjected to this sort of oppressive, aggressive behavior, not necessarily even rising to the level of a threat of violence or anything, but just feeling as though they are in constantly in fear. Swearing, insults. When I go out to MDC and I talk to the new cadets, I say, of course, you'll never hear any of this kind of language, right? And of course, we're talking about how we treat each other. And I think that tends to be something that gets lost in our focus is, I think traditionally we think about, is it workplace violence coming from an external source? In other words, a customer or a member of the public or something like that. But it can also happen internally. So we need to be cognizant of that. And then finally, at the high end of the spectrum, it's the physical attacks, hitting, shoving, pushing. I would hope at the bottom there you see, I would not have to tell you that murder is a form of workplace violence. And I wish we could joke about that, but we know we can't because we have seen too many incidents, especially over the past 5 to 10 years, of just really horrible incidents of violence that people might not necessarily associate as being workplace violence. But let me suggest to you, if we look at the, either the school shootings, the Las Vegas incident, El Paso, Pittsburgh, at the Temple, Thousand Oaks, all of those, even though the source of the violence was coming from an external source, they were occurring within a workplace, okay? So we have to keep that in mind. So there is a one true false question in the worksheet that says the county, true or false, the county expects and requires all of its employees to display common courtesy and engage in safe and appropriate behavior at all times. Well, I think you're never going to get a more obvious true than that, but nevertheless, it is written into policy. And these are things that can form a basis for a complaint or for an investigation. So it is those behaviors that create fear, and not just, well, fear of injury in general. And in the example, there's strenuous horseplay. I get all of these notices from risk management all the time about avoid strenuous horseplay. And I kind of think to myself, what is strenuous horseplay? Well, the obvious thing, wrestling, I guess. You don't want people wrestling in the workplace. But I find other things that maybe are a little bit more, I hate to say whimsical, but not necessarily with an intent to harm, but can still lead to harm. My friends, not that they do this, but my friends in IT tell me, well, what about Nerf football or Nerf darts or tape ball? Well, if you're doing that in the office, it's all fun and games until someone gets hurt. And this is a real thing, because when someone gets hurt in the workplace, pardon me, that's a workers' comp claim. That's a loss of the person's time, productivity. It's a drag on our insurance and so forth. So these are things that are real. Possessing weapons. Now, I have to put a small caveat here. Obviously, this does not apply to our law enforcement officials, people who are certified to carry weapons. This is talking about everybody else. And really what we're talking about are guns. There is in the policy a sort of minor exception for knives, and it says that people can carry knives with a blade that I believe is less, or 4 inches or less. Now I realize that there are defensive knives and EDCs that have blades that are even shorter than that, but nevertheless, that is the county's policy. Last time when I did this session, someone asked me, well, what about things like pepper spray or Couboutons, things like that? I get that we have certain operations that are 24/7. You all at behavioral health are certainly in that area, and people may be concerned if they're working the night shift and so forth. And all I say to that is, talk to your supervisor first before you start carrying anything like that, and see what their view, and they may want to talk to HR about it as well. Racial or ethnic slurs again, and then committing injurious acts that are motivated by either domestic violence or sexual harassment. And as we'll learn, sometimes someone who is not an employee, but is maybe the spouse or domestic partner, someone will choose the workplace to commit an act of violence. And I would just want to leave you with that, to think for a moment about, why do you think that is? And I'll tell you in a bit, but just why would they choose to go to the workplace for it? So where does it occur? Well, as we learned with sexual harassment, it can be both the traditional workplace and also at offsite functions, trade shows, meetings, conferences. But in the modern era, with our sort of tie to work through email, cell phones, etc., these are also means of delivering threatening messages, including social media. And so what I tell people, especially people who are new to the county, is when you're first starting out, please be very careful about sharing any of your personal contact information, phone numbers, emails, personal cell phones, and the like. Just make sure that you have established a sufficient level of trust with that person, because I can't tell you the number of times we've encountered a circumstance where someone has been just a little too free in giving out that personal information, and then we've had an issue. Because the psychological trauma of these types of incidents, and it doesn't have to be, you know, a mass shooting or an active shooter situation, just the feeling of being intimidated, fearful for your own personal safety, that's going to have a toll on people. So the broad categories we have of possible sources of workplace violence, what we call a criminal of the stranger. Now, we are public agencies, we deal with the public all the time. And so we're going to have to understand that what we're talking about here really is someone who is behaving in a way that causes you to be fearful or concerned for your safety or the safety of others. And what I say to that is just be, if those circumstances occur, then tell somebody, whether it be a manager, building security, what have you. Now, I'm careful here because I'm cautious to say this is not like the situation that occurred in Philadelphia several years ago in the Starbucks. If you recall, you know, two black gentlemen walk into the Starbucks and they don't order anything, and staff sort of overreact to this. They call out law enforcement, and it becomes this huge PR nightmare because clearly there was just the racial motivation there. There wasn't anything else that caused the concern for safety and so forth. As we mentioned with sexual harassment, equally, you do not have to tolerate violence or violent behavior from our vendors, our contractors. And dealing with the public in both contexts, I say you don't have to deal with that as well. Although in your circumstance, MDC, law enforcement, you have probably specialized training of dealing with that. But again, we want people to stay safe. The current or former employee. Now, it is the former employee I want to focus on here. In the video, they show a scenario where they let somebody go and they become more and more agitated and they start yelling, and then they let them walk out into the work area. And so these things can be avoided. If you have a circumstance, let's say, where you're about to let someone go and you suspect that they may become agitated or hostile, then have security on notice and present. If they start to become violent, have them escorted off-site, off-property. Again, the key is to how do we keep ourselves and our employees, those around us, safe. And then finally, the significant other. Again, this is someone who is not an employee, but has some personal relationship with an employee, and they choose to go to the workplace as where to commit an act of violence. I asked you a few minutes ago, why do you think that is? And the answer, I think, simply is they know where their target is. They know where their target is. And so that makes it all the more easier. And so my recommendation to people is, first of all, whether we're dealing with, again, former employees, strangers, whoever, if you work in what I consider a secure environment, in other words, a place where you can't get into it without a key or badging in or something like that, then do not allow anyone into that secure environment unless you have some form of authorization and know that they are supposed to be there. Because again, too many times someone gets into an area and now they're all that much closer to their intended target. Question that I get sometimes: what items may the county inspect for weapons? So kind of break it down simply. If it is on county property and we own it, so for example, lockers, furniture, desks, drawers, county vehicles, we can inspect that at any time for any reason or no reason at all. If it's on county property and the county owns it, we can inspect it anytime we want. It is a personal item, your clothing, lunchboxes, briefcases, backpacks, the like. We can inspect it if it is on county property, if we have what they call probable cause. What is probable cause? Well, it's more than just a guess. So in the video, for example, they show someone who walks by somebody's desk. This person has a backpack on their desk. The backpack is open and they see a gun. So that would give us probable cause to inspect that person's backpack. So just very simply, county owns it. It's on county property. We can inspect it any time. If you own it, then we need probable cause in order to inspect it. Again, unfortunately, situations do arise where workplace violence occurs. What happens and how do we try to accommodate victims of workplace violence? Well, two things, and you should have had the presentation in the first segment from EAP. They're a very good resource, and they are intended to help people who have become victims of workplace violence. Also, again, the county wants to preserve people's safety and also understand when things like this happen. And so we may have flexible work hours, put people on administrative leave, whatever it is necessary, because these things are traumatic. And we know that concepts of PTSD and so forth, they aren't limited to people in the military or in law enforcement. It can happen to anyone. And I can tell you from my own personal experience, I've worked downtown for the better part of more than 20 years now. And I will tell you that it's only been in the past 5 or 6 years where we have encountered an active shooter situation and we've had to go into shelter in place. And that's why, if you haven't already, I recommend to everyone to please take the county's active shooter training course. It's operated by SO. I think it's very valuable, get a lot of good information, and it is definitely worth the time. So just to kind of tee up what you may learn in that active shooter training, how do you protect yourself? How do you protect others? Well, first of all, just simply follow policy. As I say, we operate 24/7 operations within the county. Let's say you're working night shift, you park in a county lot at night, you notice that there is a light out in one of the lamps in the parking lot. What do? Well, notify maintenance, let somebody know. If you feel uncomfortable or concerned about going to your car at night, ask someone to escort you, whether you have security or not. And then other things that we can do, just very simply, if you go to an unfamiliar building or room, know your exit points. Many people, because we tend to be creatures of habit, we tend to exit a space the same way we enter it. And the active shooter training, you'll learn that, no, you need to reorient your thinking and think about other possible ways or avenues of escape. For example, I don't know how many of you recall the Thousand Oaks shooting that happened about a year or two ago. And that was in a bar on street level. And what they did, and this was very smart, is when it started happening, the customers started breaking the windows with the bar stools and furniture and so forth as an additional means of exiting the space. And that was very, very smart because, again, we have to reorient and not think of only the way we entered a space, because if we do that, you get that sort of medicine dropper effect, and that can be problematic. In fact, the basic principles in the active shooter is run away if you can. If you can't, shelter in place. And only when you have no other alternative do you engage. And again, 911 is never a bad call. I can tell you I would much rather deal with the 911 call where nothing happens, as opposed to a situation where someone may remain let no one knows, and then we have an incident. So, wow, I went through that incredibly quickly. Let me just make a couple of other quick points and before I open it up and see if people have questions or comments. Again, workplace violence is unfortunately not uncommon. And it, just as with sexual harassment, is something that needs to be dealt with immediately. And this includes people who may just become aggressive and yelling. We've had some circumstances with people yelling at either the public or contractors over the phone. Again, that type of behavior we have to stop, because it can escalate. And again, even in a remote work situation, we have to watch our demeanor, our behavior. And in social media, I mentioned that just briefly. I think you should have been informed that the county has a social media policy. We do, and it is one that is intended to, not that we're monitoring everybody's personal social media accounts, but when we are made aware, and this has happened in a few instances, we were made aware of someone posting things that are either of a violent nature or are inappropriate in terms of they create a false impression of representing the county, then those are things that we can take action on. And I don't know how many of you recall, several years ago, there was an incident not involving the county. It involved another law enforcement agency in the state, but it got a lot of publicity where this member of law enforcement put a posting on social media where they described their job as being a human garbage disposal unit. Well, the media got a hold of that. It was a horrible stain on that agency. And so we have to be aware that, again, the public is watching us, and they can, the public, the press, I hate to say it, law firms, they will be aware of these things, and it can not only lead to liability, but it can also lead to unfortunate situations where people may be afraid or concerned for their safety or well-being in coming to work. So with that, the concluding slide here is, again, just some of the things our office does. Also, contact information, compliance@burnco.gov. You can always reach me there. And what I like to say when I close out NEO trainings is the point of so much of this is to emphasize to you not only that we have these policies and these protections in place, but also that we have resources available to you, whether that come in the form of our office, human resources, EAP, and the like. The point is, I don't want people to feel as though they have to walk alone or that they have no place to turn. And that means that there are these multiple avenues. Again, it doesn't have to necessarily come through your management chain. You can find, and our office too, all the time, and I think I emphasized this when we did the Code of Conduct training, we are here as a resource for everyone, a safe haven, and not as a place to pass judgment or to immediately talk about anything you want to come to us with to your managers and so forth. So with that, let me again take us off of share screen. We still have a few minutes. I'm proud of myself for keeping us inside of 8:30. But again, any questions, comments you may have about the materials we discussed this time, or even in the first part? Are you aware? Were you aware that we had a workplace violence policy? And I know, Raina, you are, because it's something that I think we're going to be looking at a lot more closely. And I think, again, just the point I wanted to reemphasize is we have to be aware that these types of incidents can come from multiple sources. They are not limited to any one type of profession. Back in the day, we used to have that, well, it's still a commonly used term, the term going postal. That actually comes from an incident that occurred in Oklahoma back in the 80s. And so there used to be these sort of narrow assumptions that, well, it's only in that type of environment, or the other area where we saw a high incident rate of workplace violence was with air traffic controllers. I don't know if that would come to you naturally, but think about it. Very high consequence, high stress kind of work. And so we saw high incident rates of workplace violence there, but now we can't make those narrow assumptions. We know from the media and all of these horrible incidents we've seen broadcast in the news that they can happen anywhere. And so it's really just trying to create this heightened sense of awareness. And again, to ensure that if there are circumstances where people do feel as though their safety may be at risk, either from an external or an internal source, you need to start that conversation. because these things can escalate rapidly. And again, the county's primary goal is to make sure that people stay safe. So with that, again, any other comments or questions?
Robert, I had a quick question. I went through back through my emails and I didn't find the sexual harassment I guess document that you were talking about. And so I don't know if maybe I overlooked an email or if I just need to reach out to the presenter at the initial new employee orientation to get a copy of that, or is it on the website or the Insider?
Yeah, I would get in touch with Jay in HR and just ask, because when I talked to him before we started doing these online sessions, he said that you all would have a copy of the handbook electronically. So he should be able to get that to you. If you're looking for the actual specific county harassment policy, that is also available on the Insider. And that's under I think it's under required reading and policies and procedures. So you can actually look at it there. But the additional materials, the quiz, the worksheet, et cetera, that's all in the handbook.
Okay, thank you.
Okay. Anyone else?
No, I think I just want to thank you for putting this presentation together, and it's just good for us to be aware of it and learn some stuff today. And especially I'm a new manager at our department, so being aware of that from that perspective and just keeping an eye on things like that, because it seems sometimes like a small thing and then just it could create really big problems for our department. So I want to make sure that we're real careful on our side to make sure that all of our employees feel comfortable in all the circumstances that they're in. So thank you for your work on this and appreciate it.
Sure, no problem. I enjoy doing it. And again, to your point, I would just say with regards to both sexual harassment, workplace violence, discrimination, we have to be, and we've always been here, but I think we've again had this heightened awareness. We're in an era where words matter, and we need to keep that in mind, that our words do in fact matter in a variety of contexts. And so we just, again, a big part of this training is not only to make you aware of the policies, but to sort of make sure that we are thinking, acting, speaking in a way that is professional and appropriate, and so that we can be the role models for all of those people around us. So unless there's something else, I want to thank you all again, and I appreciate your time. And as I said in the Code of Conduct training, let's not make this the last time we talk with one another. Let's keep the conversation going. Our office exists as a resource for all of you, and we want to keep the conversation moving. So with that, thank you all. Have a great day, and we'll talk to you soon. Take care.